Learned counsel for the appellants argued that the amendment of the Gratuity Act is to grant liberalized benefits staff. Therefore, it would be retrospective, reliance is placed upon judgment of this court in Commissioner of Income Tax within bracket central bracket out first, New Delhi versus Vatika Township Private Limited, under bracket 2015 1 SCC 1 star. The aforesaid case is of insertion of proviso to section 113 of the income tax, providing that tax chargeable under the said section shall be increased by a surcharge and shall be applicable in the assessment year relevant to the previous year in which the search is initiated under section 132 of the said act star. It was the said provision which came up for consideration before this court star. This court held as under para code. In such cases, retrospectivity is attached to benefit the persons in contradistinction to the provision imposing some burden or liability where the presumption attaches towards prospectivity star. In the instant case, the proviso added to section 113 of the act is not beneficial to the assessee star. On the contrary, it is a provision which is onerous to the assessee star. Therefore, in a case like this, we have to placed with the normal rule of presumption against retrospective operation star. Thus, the rule against retrospective operation is a fundamental rule of law that no statute shall be constituted to have a retrospective operation unless such a construction appears very clearly in the terms of the act, or arises by necessary and distinct implication star. Dogmatically framed, the rule is no more than a presumption, and thus could be displaced by outweighing factors star. Decode para. Learned counsel for the appellants also referred to a judgment of this court in D.S. Nakara and others versus Union of India, under bracket 1983 1 SCC 305, to contend that the cut-off date as 24/5/2010 has created two categories of employees, first, who have attained the age of superannuation before the said date, and second, who have superannuated on or after 24/5/2010 star. Such classification is illegal and arbitrary in nature. Star para. On the other hand, Mr. Vikramajit Banerjee, learned counsel for the union, has argued that D.S. Nakara's case deals with pensioners, who get recurring benefit every month, whereas, the gratuity is one-time payment star. This court has held that the cut-off date so as to grant benefit of pension to the retirees after the cut-off date and to deny the retirees pension before the cut-off date is arbitrary star. It was thus argued that benefit of gratuity stands on different footing, than recurring right of payment of pension star. This court held as under para code. What then is the purpose in prescribing the specified date, vertically dividing the pensioners between those who retired prior to the specified date and those who retired subsequent to that date? That poses the further question, why was the pension scheme liberalized? What necessitated liberalization of the pension scheme? Para. If it appears to be undisputable, as it does to us that the pensioners for the purpose of pension benefits form a class, would its upward revision permit a homogeneous class to be divided by arbitrarily fixing an eligibility criteria unrelated to purpose of revision, and would such classification be founded on some rational principle? Question mark.